on to source code.
So it's, you know.
Okay, we're live.
You're drinking water. I couldn't see all it looked like a ball.
Okay, if I get everyone's attention, we'll start the meeting now. And gee, thanks for the great attendance.
Not singing, totally not.
Welcome to the Rocky Mountain Veterans Association.
Totally not.
Oh my gosh, amazing.
So we're a 501c3 nonprofit. Actually, this would mark our 41st year since 1978. This group's been around in one form or another. Dedicated to education of inventors. And our mission recently has been to focus on helping people transition from product to business, which always seems to be the hardest thing to do. You know, people get a prototype made, they might get a patent trademark, and then they get stuck. And because it's a whole different ballgame and turn it into business, and sometimes they're trying to license, and there's a lot of struggles in there. So we're always trying to help refer, network, do all these things, and have presentations in lots of different areas, you know, funding and finance, prototyping, entrepreneurs, intellectual property, finance, accounting, all kinds of different subjects. So we're always looking for suggestions too. So we normally meet second and fourth Mondays, same time and place. Once in a while we do joint meeting or training with the Denver Public Library downtown on searching. Be one to do. And there's always meetings at the patent office. On like trademark specific items, various other intellectual property. So, like for instance, we have our next meeting in 2 weeks. Avid Engineering from Loveland's coming down. So they do prototype and some small scale manufacturing, 3D printing, molding. Could be an option for prototyping. And then next month we have Level Terrain coming, and so they've got some products on Amazon, and they've sold several million of this thing called Flip Belt. And so they go off and they help inventors on certain products they feel they can work, help them get their businesses going. They know Amazon well and stuff, so that's critical these days. And social media pretty good.
Flip belt?
Huh?
Flip belt? Flip belt?
Flip Belt.
Yeah. That's my client. Oh, it is?
Oh, it is? Okay.
Leah?
Warren Doe. You know Warren Doe?
No, but Leah was the inventor, right? Let me get the flip belt, the little.
Yeah, it's the one that's kind of made out of scuba material.
Yeah. She was like, yeah, I'll talk to you later.
Oh,
I know her.
so yeah, I think, someone else invented it, and then Warren Doe and them kind of took the business.
Yeah, her brothers took over.
Yeah,
Yeah.
but I think it's been a pretty successful product.
Great story.
Yeah.
Yeah.
So it's always good
That's so
to
funny.
get everybody excited about some
He's
successes
definitely
in this area.
whispering his ear. I go, have you heard of flip belts? It's so funny.
So anyway, what we usually do is a round robin. Everybody take a minute and talk about what you've got going on. Just remember, if you've got an idea and you haven't already publicly disclosed it and you're not patent pending, to keep it confidential. Or you can just
Don't
talk.
do that here.
Yeah. This is a public forum, so you could talk about it like very generically, like maybe the function, but not how you get there. So yeah, don't say too much, because once you did, you can't bring it back. So I guess I will start over here, and then we'll come around, and then after everyone's done, Molly, who's from the Denver Patent Office, will begin her presentation. And we always have Q&A running during the presentation, so don't hesitate to ask. We do live stream on YouTube, and then this is video recorded, so you can access it later. Our handle is RKYMTN Inventors. So you just search that on YouTube. There's also a link on our webpage to get to our channel. We have well over 100 videos, on various topics, and they're searchable by date, presenter, and topic. So there's a good library there.
I think I'm there.
Yeah.
Perhaps once or twice before.
Yeah. So I'll start with Brad.
Name is Brad Brandon. I guess where I'm in this process, I'm an environmental engineer, and I'm the guy that's been writing down ideas on those sheets of paper for the last 20 years. And finally, agglomerated them all into a big spreadsheet, and I'm in the process of going through which ones I think I want to pursue. So.
Okay. Jay.
I'm Jay Wilkinson, and I'm recently retired, and I didn't want to do very much because the county that I work for, Boulder County, seemed to think that they my mind while I was working for them. And now I'm retired for 3 months, so I think I'm free of that. And I do have one thing that's out in the world. I invented a handle for my dentist, and we did a kind of a swap. I gave him the handle, and he puts in my. I have some attachments that need to be put in, and so I have to buy the attachment, and he does the labor for free. I have this deal going with him because I saved his hand.
All right. Dana?
My name is Dana. Been on and off with you guys for a long time. In a nutshell, not working on anything particular. As some of these guys that you already knew, got a lot of ideas. I've shown some of them. 9 working on patents, 24 on the drawing board, like 1,000 in my head. And actually, I told you guys and a few people that were here last month about my Las Vegas idea. If you want to hear about it, look for partners. If you're like really religious, you probably don't want to hear about it. But if it's Vegas, you probably want to ask about it. Like I said, I just got a lot of stories all over.
Steve.
I've been inventing things for a long time, about 38 years, always for somebody else. I've invented something for myself that is a device that loads and unloads pallets from vehicles. So.
Okay, Bob.
My name is Bob Custis. I'm new to this whole process. I've been working with Russia for a couple of years. I have a couple of ideas that we're currently working on. Hopefully both of them will make the world a little bit better. It's also going to do a lot of work, so I have to deal with that. Also, people hopefully live a lot longer, so we'll see where this goes.
You gonna say? Dan? Yeah.
I play devil's advocate for my brother. He comes up with ideas, I try and present a maybe a positive side of his idea.
I need you.
Oh,
And that's my part.
He charges a lot for his name of year.
Always push the positive.
That's right.
I love it.
Sweet.
My name's Sweet. Basically working on a new type of game console stand for the Xbox One and PS4 game consoles. Just went through the first round of testing and kind of making changes from that I got from that, and trying to cut down, also making changes to cut down manufacturing costs.
Okay, go ahead.
Hi, I'm Lindsay. I am the founder of a company called Easy Peasy. This is what it looks like. It's a little mad. I didn't bring any because I didn't really know what meeting was. But essentially, I'm not an inventor by trait. I guess I grew up and I played soccer and I worked in corporate America my whole career. So I spent my career in corporate America and thought that's what I would be doing forever. Luckily, I had 3 boys and I was blessed with identical twins. Ironically, this used to be our church. We lived in Wash Park, so they were all like baby dedications here, which is even weird. So we have like the baby dedications here. I'm not that religious, so I'd be okay still listening.
What kind of question? You're required to have traits? I might not supposed to be here.
Oh my God.
You can take off the hat, but you're fine.
You're a Bravo fan?
No one claims that these days.
And I still do.
No, you're bragging.
I'm also a Buffalo Bills fan, so that
Oh,
tells
wow,
you, yeah, see,
you're-
I know how to be
you're looking for
loyal.
punishment.
I know how to be loyal.
Actually, I think I'll take a little spin on my story. So luckily, we've been very successful. So I have 3 boys. They were messy one night at dinner. It's the very cliche story of, my husband identified the problem. He said, there's gotta be a better way. I went to work the next day, realized nothing existed. So I came home and I taped a bowl to a piece of paper and told my husband, I'm gonna create a product and start a company. Bought a book, and within the next month, I had prototypes and found a really good patent agent, local in Colorado, he's not here. And he wrote a really good utility patent, and so we got the utility patent granted. So I was just actually looking. So we've got a really extensive global IP portfolio, and Molly's heard me talk. We have 75 trademarks, 13 design patents, 4 pending. We have some trade dresses, and then we've got a utility patent in the United States and Canada, and we have a PCT filed in 39 countries. So we have a global portfolio. We've been on Shark Tank. We're in Nordstrom and Target and Buy Buy Baby and Pottery Barn and Crate and Barrel. So I would say I'm living kind of like what everyone strives for, right? But the flip side is I'm in a really bad litigation. So 2 years into our journey, I got sued actually. So they initiated a suit on us. And so they've sued me personally twice now, which I've been dismissed. And now we've been in this litigation, it's been 2.5 years of just a big manufacturer trying to invalidate our patent and do lots of stuff. And so these are actually my new patent lawyers. So I had outside counsel in Detroit, and then we just shifted folks to here that are taking on the case. And so it's been a fresh start and really interesting kind of just from a patent perspective, looking at every angle of the patent. So it's been a really good story, but it's also been really hard. And this case is really hard.
How much revenue is your product at?
Yeah, so we are gonna do, so we have about 7 million in sales a year. We're projecting to do around 10 this year.
Although Lindsay is responsible for what might have been a security incident on the cruise that we took over the summer, because there was a couple getting into the elevator and they had one of your happy mats hanging off. And I couldn't, it may have been after dinner. I may have had a few adult beverages. I'm like, I yelled at the woman in the elevator. And this couple was clearly, they weren't American. So they were like, holy hell, who's this? That's amazing. And they're hitting the button on the elevator.
Oh my God. I've yet to see one in the wild, so I was actually in New York and someone saw it at lunch, like somebody eating out of a restaurant, which is like what I'm very excited.
They took it on the cruise, which was genius.
That's
Genius, yeah.
total other sales channel. So it's been really good, but it's also been, I think I've experienced the hardship of, we've spent $1.5 million in litigation, and my husband's been served, and we've been served, and the ugly side of the business. So with every good story, you have to overcome challenges and persevere, and so that's how I, stay positive, and so that's where we're at. It's still fun.
Good. Rick,
I'm all about the people. As long as you have good people to fight the bad guys, it's all good.
and Rick's, I should say, he's been involved in this group for a very long time.
That's true. I went to law school when I was 40, 2 years ago.
Wait till you hear when I went.
Dementia and numbers, and so I'm 74. And I'm proud dad of a 14-year-old daughter, which is, of course, the center of your life. So I've got over 1,000 issued patents since '86. I sued Walmart, won a full trial 15, 16 years ago. I spend 15%, 20% of my time, who knows, average, in litigation with full-time litigators. Ronnie's been my battle buddy for a dozen years, and his wife. They got married in law school, and they're the proud dad of a new son. We're all parents here, by the way, see? We're all 3 of us here. And big at the club, yeah. So that's what matters most. And so I used to be an IBM street salesman in Manhattan, knocking on doors, selling $500,000 computers, getting thrown out. I want a typewriter, you fool. What do I want a computer for? Anyway, picking yourself up, going to law school when I was 40. And so my business has always been an entrepreneur like Lindsay, fighting to build lives, Walmart and so forth. In 3M, we're going to trial in April against Kenobi Martins, with 500. I think there'll be 15 lawyers against me and my buddy, That's fair. So,
That's just fun.
Okay, so when we hired him, the first thing he said to me is like, this firm against you, you got your money, it's like a 250 man firm. And I'm like, I have no idea. So
well, actually 200 grand. But, there's about 60, 70 years of age, good patent lawyers against us in this case here. It's like wine, you look at the age. So but I got 30 and that's a fair 2 to 1.
Yeah, but you gotta ask whether they corked that bottle right as
yeah, this is so good.
Do they give it away? They sell it. But anyway, I've been the whole thing. I've done my 5,000 small business interviews, and I have stories that would write a book, which is something maybe I'm going to do. Oh, I did write a movie. It's called Russian Decepticon. It's on Amazon. Sorry, it's a submarine war movie that is trying to get to Hollywood. So when I'm not writing it back, I'm creating something for your pleasure. You can download the book at Amazon. Russian Decepticon. Putin puts a submarine in a Fort Lauderdale harbor to surprise us.
And he has 500 stories, so if you want to real quick, don't have Rick with you.
The book will all not buy me a good Starbucks coffee. This is Ronnie.
Sorry, I'll stand up so that, my name is Ronnie Fisher, I'm an attorney. I litigate, as Rick said, his firm and our firm litigate together. We have 3 attorneys in our firm, paralegal, receptionist, secretary, and all the above. Full service litigation firm. We primarily specialize in intellectual property. However, we also help people from the ground up. So for instance, as you get your company going, to add some more credibility to your business model, you may want to incorporate, set up in a limited liability company or an S corporation or so forth. So we help you navigate those waters, so to speak, so that you have a little bit more credibility to who you are and what you're selling and so forth. Also, the benefits are to limit personal liability. You guys are inventing things, the last thing you need is your house to disappear because of something you invented. So from that perspective, we help you with that. We also assist you with evaluating whether or not you need a trademark, copyright, whether or not what you have to be utilized as a trade secret. Think of like the formula for Coca-Cola, essentially something of that nature. So we'll help you work through those problems. To the extent down the road you make something that's successful, I assure you it will be the product and victim of litigation. Why reinvent when you can copy? It is a great model for some, which they believe that is their business model.
I like to say the world is full of emulators and short on innovators.
Yep, right.
Perhaps the country's philosophy.
Yes, exactly. There's one in particular kind of that way. My point is that when that happens, we're happy to help you navigate what your rights are and how to enforce it and so forth. So that's me, and my firm is Fisher & Fisher.
Not Vegas is an innovator.
I love Vegas.
My name is Dylan. To my knowledge, I am not a parent, so that's.
I had one time in Las Vegas.
I heard different.
Don't be confused by the church. No confessions, people.
Feeling weird.
Yeah.
You guys know the definition of a bachelor, don't you?
No.
No children to speak of.
Yeah.
On a more serious note. I'm the Chief Scientific Officer and Head of Research and Development in Ty's #2 First Mate. We started a company together, primarily focused on biotechnology and consumer electronics. We're in prototype mode right now, so. Yeah.
Good, all right. So you're in the trade secret phase.
Yeah.
All right.
I'm Ty, I work with Dylan, I'm the CEO of my LLC we just made. We're trying to make products in the pet electronic industry right now and generate enough revenue to pursue biotechnology stuff that we want to do. It turns out that's really expensive, so we have to raise money for that. So,
Yeah.
And Roberto.
I'm Roberto Schena. I'm a patent agent. I've been practicing patent law for 15 years now. I'm the US correspondent of few Italian law firms, since I'm Italian. So I'm doing the filing and prosecution of patent application that usually have been already filed in Europe.
Okay.
I might mention, Roberto and I are on the board of the Rocky Mountain Inventors Association. Of course, you know, I'm Roger Jackson, patent attorney too. I started this group in '99, so I'm at 20 years.
Oh my gosh.
Yeah, I can't believe it. That was my second career. I was like Rick, I was an oil and gas engineer for 23 years and then switched over to patents. So, without further ado, I'll introduce Molly, and she will take it away, and please ask all your questions.
I was gonna say, so this goes a lot better if y'all ask questions, because then I know that you guys are getting the information that you want. So there's a lot of information here, and it's all about getting it out to you. So, and whoever asks the best question, in my personal subjective, and I am the single and sole judge of that, just for the record, we need to set that straight, because I got questioned once about the questions. So I have a set of Inventor trading cards. One of the things that the U.S. Patent and Trademark Office does is that we try to educate everybody about different inventors, and we happen to think that inventors are just as cool as baseball players. So we have an entire packet of Inventor trading cards right here. They're very, very cool. There are some really interesting ones in there. My favorite is a young lady named Beulah Louise Henry. And for those of you who might be interested, she invented the vacuum sealed ice cream freezer. So, or freezer, which allows you to have Ben and Jerry's in your home at your convenience.
Oh my gosh.
Yeah, she's kind of an awesome lady. Okay, so by way of background, because everybody did introductions, right? So I have actually been a patent attorney for over 20 years. We don't say exactly how many over, because then you're gonna work backwards and figure out. I was a chemical engineer, but I worked in the nuclear industry, so I had a lot of different experiences. Working in the nuclear industry, though, you work with the government, and then I ended up working for the government again. I really don't understand. But anyway, so I was in private practice. I did patent prosecution. I've done every form of intellectual property that there is to do. So if there's a rodeo, I'm pretty sure I've ridden in it. I might have the belt, the sash, and the crown. I'm working on the scepter though. No one has given me a scepter. I think because they think I'll beat people with it. You know, so that's one of the things. And then I was in-house at several different companies. The first one was First Data. I saw your little swipey thing from First Data. That's very cool.
Yeah.
I'm pretty sure I authorized the patent for that.
Oh.
So
Well, they own the credit card business, don't they? Pretty much.
They do. So that was a fun company to work for. And then when they got bought by KKR, Colbert Gravis and Roberts, when they were taken private.
Oh, private equity.
I moved over to Quest thinking, oh, that's a Colorado company. I'm going to get to stay in Colorado. And then Quest got bought by CenturyLink and moved their headquarters to Louisiana. Nothing against Louisianans, I love y'all, but I'm a Colorado girl. And so then I moved to Oracle, and then from Oracle I became the regional director of the Rocky Mountain U.S. Patent and Trademark Office. So, like I said, I've done pretty much every form of intellectual property there is. I've seen every single side of it. And more to the point, right, like one of the things that I did for all of the companies that I worked for was the intellectual property due diligence. So whenever my company was buying yours, or if you were buying a company from mine, I was the person who was handling all of the intellectual property. And I always called it like hunting for the odd sock. You know when something's missing and when something doesn't add up. And we'll talk about intellectual property stories in a minute. But, wait, did I do it? Oh, it's not letting me, Roger. Am I hitting the wrong button?
There it goes.
Oh, here we go. Okay. So we talk about raw property versus intellectual property. I actually like to say that the process of patenting and trademarking is taking intellectual property and making it into real property. Because, right, once you have a registered trademark, once you have an issued patent, a registered copyright, or a trade secret that you can articulate what it might be and protect, you actually have assets on behalf of your corporation. And they're just as saleable, just as monetizable as the desk, the computer, and everything else along those lines. So I always like to talk about real property versus intellectual property because then you know, you kind of get the difference, but it really is the process of turning intellectual into real. Yeah. There you go. I have no idea what that's for. Okay, so why is IP important? I think it really is important for everything, but we'll go through the different classes. So intellectual property is the umbrella nomenclature or term, right? But it refers to 4 different forms of intellectual property: patents, copyrights, trademarks, and trade secrets, right? So when you are talking about your company and you're talking about protecting whatever it is that you might have come up with, you want to be thinking about everything under that umbrella. It's not a one and done type of situation. It's an evolving thing. You can think about it as an annual checkup, but you probably, especially in the early stages, want to be doing it more than annually. But you want to look at what's going to work for you, what you can afford, what you can protect, and where you can go from there. So, right, we'll start down at the 0 cost to obtain, which is a trade secret. There's any information that is valuable that distinguishes you from your competitors. However, the place where people make the most mistakes in trade secret is that they can't articulate what it actually is. They can't tell you what the trade secret is. And because they can't tell you what the trade secret is, they don't take the appropriate steps to protect it. So everybody in the small company knows everything about the product. They know everything about the process. Or my favorite is the guy who said that his manufacturing process was a trade secret but gave public tours of his manufacturing facility. Okay? If it's a trade secret, you have to keep it a secret. That means liberal use of non-disclosure agreements, liberal use of confidentiality agreements, liberal use of making sure that the people who need to know are the only people who know. You've got to be very discerning. And I know that in today's open society, you want to treat everybody equally and you want to make sure that people understand and that they get it. When it comes to a trade secret, if this is going to be your methodology of protecting your intellectual property, you've got to keep it a secret and you have to be very discerning. And that means sometimes telling someone, no, you can't know that. And no, you can't have access to that part of the server. Right? It means every single measure. And it's a sliding scale, right? Because it's judged at the time of the trade secret. So from a cybersecurity perspective, from a computer perspective, you're going to be judged on today's standards, not the standards of the perhaps 70s, 80s, 90s, right? You're going to be judged on today's standards. So you've got to make sure that you're taking those steps. The one good thing that Congress has done in a while, in 2016, they passed the Defend Trade Secrets Act. So for a long time, trade secrets was what I called the redheaded stepchild of intellectual property, because it was a creature of state law. So there were 50 different state definitions about what a trade secret was, 50 different state definitions about what it meant to protect a trade secret, and 50 different state definitions of what it meant to steal a trade secret. That all changed in 2016 when Congress passed the Defend Trade Secrets Act. Now you can actually try a trade secrets case in federal court. So there's one definition of what it is, one definition of what it means to misappropriate it. It's kind of awesome. And you're in federal court where judges kind of like you. State court, the judges don't really like the intellectual property lawyers. So that's that. We were complicated. I don't like that. Okay, so 2 of the most famous trade secrets, right, are the Coca-Cola recipe and the 13 herbs and spices and Kentucky Fried Chicken. I think the special sauce for McDonald's usually write a trade secret as a recipe or a manufacturing process or something that isn't intuitive and can't be reverse engineered easily from your invention, right? So that's what you want to be thinking about. 0 cost to obtain, tons of money gets sunk into the confidentiality and protecting it, right? So that's where your money comes in. On the copyright side, this is any creative expression stored in a tangible form. So anything, right? Music, art, books, literature, screenplays, movies, all of those other kinds of things. Those are all the subject of copyright. But in today's world, software, right? Application programming interfaces are definitively the subject of copyright. That was decided in the Oracle versus Google case. So, right, you really do want to be thinking about copyright if software is the realm that you're in. And you want to be using copyright and patent in that software world as 2 pillars and suspenders. right? You can't ignore one and leave the other behind. Yes, sir.
What about copyright, copyrights on engineered drawings or system designs? Not necessarily a patentable thing, but you just don't want competitors to take your design and use it.
Okay, stay with me here because we're going to get into the existential part of this conversation. Feeling very, we're in the right place for this conversation. All right, so copyright exists the moment it's fixed in a tangible form, right? So as soon as you hit save, as soon as those drawings are finished, as soon as you've got, you know, the sculpture exactly the way you want it, copyright actually exists under the Berne Convention, right? And it exists everywhere in the world. However, if you want to enforce it, because all intellectual property rights are global, but they're territorial, so you can get them anywhere, but if you want to enforce them, you have to have an intellectual property right in that particular territory. Does that make sense? Okay, and so copyright may exist, but if you want to enforce it against anybody, you have to get a copyright registration, right? So you can do it, but copyright, the standard for infringement is substantial similarity. So, right, you wouldn't be able to tell whether or not someone had infringed the drawings from a copyright perspective just by the product that they produced. You would actually have to show that they had access to the drawings. So that's one of the things, right? You want to be judicious about where you're going to be putting your time and your money. Now, right, copyright is 75 bucks. I usually spend more than that anytime I shop for Legos for him. My son is in the back. So, you know, we're hitting 75 for every single one of those Lego sets, right? And perhaps maybe if I just copyrighted something else, it would make me more money from him. But, right, so it's pretty cheap and easy to be able to file a copyright registration, but you want to take a look at that and really, you know, how would you find out whether or not somebody had infringed it? It might be a longer and laborious process if you're just working off of the engineering drawings, right? Okay. So that's copyright. We're going to go up in the world because this is, I said, $75 to obtain the copyright registration. The trademark registration is $240 per goods per class of goods or services. So if you are selling software as a license and then also software as a service, that would be 2 trademark registrations, right? So that's one of the things. It's a little bit more expensive, but it does provide you with some interesting things. Especially a federal trademark registration provides you with the presumption that you are the owner of that trademark in all 50 states across the nation. So there are state trademark laws where you can get a state trademark. For some businesses, that's probably appropriate, especially here in Colorado, because one of the things that you have to allege and that you have to show when you're filing a federal trademark registration is that you are using the mark in interstate commerce. So there are certain businesses that are here in the state of Colorado that perhaps don't want to allege that they are doing business in interstate commerce, like across state lines. They need to stay here. So, right, a Colorado trademark registration might be appropriate for those types of businesses. But, right, if you are selling on the internet, if you're selling in e-commerce, if you're going to sell with Amazon, you really, really, really do want a federal trademark registration. So we're going to talk a little bit about choosing your mark too. So we have what we call the spectrum of marks. So we're going to start. I always use Mexican food, and I really need to stop using Mexican food for this, but we're going to do it again. All right, so we have the spectrum of mark from generic all the way up to arbitrary or fanciful, right? So generic mark for a Mexican place might be the burrito place. So what do you think you're going to get if you walk into the burrito place?
A burrito.
Right, right. There's no mystery. There's no sales. There's no.
I want a taco.
But it's the burrito place, right? You know, there's nothing protectable about that from the U.S. Patent and Trademark Office's point of view, right? So the burrito place is what we call a generic trademark. It is just the generic term that goes along with whatever it is that you're selling. Yes, sir.
But if I were to open up a burrito place and use the words "the burrito place," You're telling me that I couldn't get a trademark?
Not right away. The US Patent and Trademark Office, from a federal trademark perspective, would reject that as generic.
You could if you were selling pink underwear.
Yeah,
But if you're selling burritos,
if you're selling burritos at the burrito place, we're gonna tell you that that mark is generic and it is inherently non-registerable.
okay, so Steve's Burritos,
Ah, all right. So now you're moving up, right? So Steve's Burritos, we might still reject it because presumably they were burritos made by a dude named Steve at one point, right? That's descriptive. Okay, because you're still in that burrito place, right?
right?
Right? Okay, so you're following me, right? So generic is the burrito place. Descriptive is probably Steve's Burritos,
Right,
right? Especially if Steve is the dude behind the counter,
right,
just saying.
right.
Okay, right? Those two types of marks we say are inherently unregisterable. Okay, so you don't want to be in generic land and you don't want to be in descriptive land, right? Now we're going to move into something suggestive, right? Suggestive is perhaps Chipotle. Chipotle is a pepper. It's used in Mexican food sometimes, not in all Mexican food, right? Because you don't always want that smoky flavor, but right? It's something that gives you a hint that you might be able to get a burrito, but you might also be able to get a whole bunch of other things at Chipotle.
Right.
So that is what we call a suggestive mark. That is registerable from in front of the U.S. Patent and Trademark Office.
If I change the name from burrito to burrico.
Interesting, could be suggestive, right?
Okay.
Or if you spell it differently or use it like one R or, you know what I mean? Yeah, if you use a misspelling, sometimes you can take a misspelling and make it suggestive versus descriptive, but you're still walking a really fine line there. Okay, and then you go into the arbitrary and fanciful land. And my example of that is Qdoba. Right? I don't care what the internet says. It does not mean anything in any language. Absolutely not. Completely made up. Right? And yet, if I say Qdoba to you, do you start salivating? Because you know, right? Like you're going to get fast Mexican food. You're going to get a really good taco there.
It implies Adobe,
That's interesting though.
queso, a lot of things.
Were you in that brainstorming
But
session?
it implies. It doesn't tell.
Right.
Right? And it's a made-up word because the Q doesn't have anything, right? But right, it's a made-up word, and that's arbitrary or fanciful. And so when Qdoba first started, no one associated Qdoba with Mexican food. But now, right, we all have that consumer association. So one of the trade-offs is, right, if you come up with a really unique and fanciful arbitrary name that is inherently registerable in front of us, you're going to end up spending a little bit more on marketing to make sure the consumers start associating your goods and services with that mark, but it's totally worth it in the end because you will have a mark that if anybody else comes along, because it was arbitrary and fanciful to start with, it's inherently registerable, it's that much stronger of a mark. So when you're thinking about your brands, right, you really, really, really want to be thinking about something that's unique. Make it yours, right? That's what you want to do. We have lots of trademarks. So one of my favorite ones, one of my favorite stories is the Apple story. Does everyone know that origin story? Right, so in the 70s, probably before you were born. I'm going to talk to this side of the room now. These are my people, right? We remember the time before Apple's computer, right? Okay, so there was a little band over in England that had a company called Apple Publishing.
A little band.
Little band called Beatles, right?
Right.
So Apple Publishing took umbrage to Apple Computer and said that no, when it comes to, you know, a company that has Apple as its name, that's using fruit in a weird fashion, we want to be the only people who own that. And so they actually opposed Apple Computer's trademark. So Apple Computer, Apple Publishing come to the table and they They arrange what's called a consent to use agreement, right? Because you can do that. And so Apple Computer said to Apple Publishing, well, we'll never get into the music business.
Well, they could have,
This was 1973.
right.
Okay, well, we've been in the business for 50 years.
We won't get into that, right? Well, that consent to use agreement didn't have an expiration date.
What?
You can Google how much Apple Computers paid to Apple Publishing in order to be able to launch iTunes Music. It's on Wikipedia. It is an unholy number. So when I tell you to be as unique as possible, be as unique as possible, dream your dreams of world domination. Please do be as unique as possible and make sure you corner that market on that mark. Don't pick a mark that you're going to have to give someone else the ability to tell you what you can and can't do with your business, right? Because Apple Computer couldn't launch iTunes until they talked to Apple Publishing.
Right.
So with the money they got from Apple Computer,
They actually,
so now they're changing the name to Global Publishing?
no, I think they actually went back and bought the rest of the Beatles catalog back from Michael Jackson. Because all of that happened about the same time.
Yeah.
So I can't prove that, but that's my theory.
No, they did do that.
Oh, no, they did do it,
Yes,
but I can't prove that the money that they got from, right, like, so it's just my theory.
Michael Jackson made a ton of money on it.
Yeah.
Oh, that's what kept Neverland going for so long.
Yeah.
Good or bad, right?
Yeah.
Anyway, okay, so we talked about trademarks. And the thing that I like to tell people, especially about a federally registered trademark, on the enforcement side of the house, right? You get a lot of help. So Amazon, eBay, Alibaba, if you have a US federally registered trademark, they will take things down for you from their marketing platform if you can prove that you are the registered owner of that trademark, right? The other people who will help you out, they're called ICE. I know they get a really bad reputation for some of the things that they do, but the customs agents who stop things in the ports are amazing. And shockingly, one of the largest ports in the West is right here at Denver International Airport. So lots and lots and lots of goods come through in DIA through shipping. So they work for you. And it's like $195 to file the customs for a trademark.
Yes.
Yeah. So, and then you get agents around the nation working for you to keep goods from coming into the country. So it's a really cost-effective mechanism of getting rid of people who are bound and determined to rip you off.
So one thing that's interesting from Amazon, you're absolutely right, Amazon will take down from trademark infringement. What they haven't implemented is people can bid on your trademarks and buy them. So if you go to Amazon, everyone buys easy peasy, and it's, all of their ads come up first, which seems like illegal. And so that's something that we've taken up with Amazon. So, right, they're using our trademark to advertise.
Yeah.
So that's just like a gray area.
It is a gray area. And they're working on it. We talked to them about it.
Just a quick question. You need a trademark for the logo, the name, and the slogan?
So you can do it any number of ways, right? So a lot of people start with what we call a word mark, which is just the name. But if the name is more on the descriptive side of the house, and you want to beef it up with a logo, you might want to file what we call a composite mark, which is a word mark and the logo together.
Gotcha.
Right? So that limits you though in terms of how you grow. If you do just the word mark, right, without any stylization, and you get a registered trademark for your word mark, you can grow the stylization to where you're finally happy with it. With a logo, you're kind of stuck right away, right? And no matter what you do, before you choose your name, come talk to us and search the trademark database with us. We can help you do logo searching and that kind of thing, because you don't want to invest your money. And here's the one thing that I tell people, and they think I'm crazy, but I've seen it so many times. Intellectual property decisions are shockingly emotional, okay? You get attached, right? Like all of a sudden, this is your identity. Easy peasy, the happy rat. This is like, it becomes part of who you are. And so before you get attached, right? just like you would do your due diligence before you get married, right? Really research them. Make sure that you know what you're getting into and know if there's someone else out there who has the same name, the same logo or something like that, so that you're not out of the gate, subject to a cease and desist letter.
Is there,
Sweet.
do you, if we go there, is there someone there to help us? Okay.
Yeah, that's crazy. So you guys just have that service? That's amazing. Yes.
And then the public library, on the
Yeah,
page for
and we-
reference, they help you too.
We also offer that through our some public libraries. We call them our Patent and Trademark Resource Center. The one here in Denver is Stephen Schenck.
Yeah,
Schneck.
Stephen Schneck, S-C-H-N-E-C-K, yeah.
Is it similar to the patent search? Because I did the patent search.
Yeah. Yeah, and we have someone in-house that can do the trademark search too.
Patent office intranet,
Yeah.
but just
So-
that downtown.
And again, just like I'm telling you to search the trademark to find out before you like marry your brand.
I'm kind of in that situation right now.
Okay.
I would say another just general thing of kind of funny story. So our mark is easy peasy, and it's just the 4 letters, easy peasy. When I started the company, the domain easy peasy wasn't available, so I bought, our original company name was EAZY-peasy, and I was dead set, like it has to be this, and the domain matched, and so that's the name of our LLC, and someone was giving me advice, and just at the end of the call, she goes, I have to tell you something, your name's terrible, no one's gonna be able to spell it, and thank God, and I immediately didn't take it personal, but I was like, she's absolutely right. So I took the advice and I just changed the name and stuff. And everyone screws up the spelling, our LLC and stuff. And so, again, one, be flexible. I was so dead, and then take feedback too. And like ask people for feedback that you don't want to hear. Of course, it's like this stuff, I already have my logo and anyhow.
You want a name that's, it's kind of a complex thing. It's like you want it unique, but you want it kind of simple and easy to remember to say. Because like, I was researching on Amazon, their original name was Abracadabra. And it's like, oh man, that was a good choice. Like that change, because see, that's a name people can't spell, right? And then they're not gonna get this Google
I was
search.
just curious.
Trying to think about, I'm gonna end up misspelling my own name.
Where's their idea for that?
Yeah.
But,
I don't know.
I mean, everybody will, you could be referencing the Amazon and people won't even
Right.
the website.
And that's exactly what you want to do with your own business.
And don't forget,
services,
you
is that
can do a
instant
scent,
recognition.
you can do
Oh, yeah,
color.
there's
you
scent,
can do,
there's color, there's sound.
Music or sound.
Yep,
You can do all
and there's
those
also 3-dimensional shapes. So if you
Trade
have
dress, like Apple's got their store layout.
the store layout,
trade
all
dress.
that, do we have some of that? I don't know, maybe.
So you mentioned about sound.
Sound, yes.
So,
Like a Pentium sound.
well.
No, if
my-
I go do, what news show am I watching?
NBC, all I know is it's
There you
NBC.
go. There you
So like the sound before the movie starts, THX uses. I can't
Uh-huh.
use that. I can't use that.
No,
Without
you can't, without their permission, exactly. Or if there's a lion that
Was that
roars
your
at
last
the beginning of
Oh,
something.
no, that was another idea.
I have a word that I filed with the help of this guy.
Okay.
No, it's approved.
And it did? When?
In October, I think you. Anyway, you got your notice of allowance, so,
I got the notice of allowance, but I don't know what that means.
well, you gotta put it in commerce by April or by time extensions.
Okay.
So
So
there's 2 ways of
you're in
filing.
like almost registered, but not quite.
There's 2 kinds of trademark applications. One is called an intent to use and one is called a use. So if you file a use application, you actually have to be using that mark in interstate commerce right now and be able to prove that to us. If you file an intent to use, you say, I have the intention of using this mark in the future. It goes through the entire examination process, and then you have a period of time after you get your notice of allowance where you have to use the mark in interstate commerce.
Okay, so what I've got is,
Intent to use, which most people do. They wanna know that they've got the name approved
right,
before they make the commitment,
Absolutely.
put it on their product.
And
and now
everybody
what I've
does
done
that,
is-
right? Lucasfilms, If you want to know what the next Star Wars character is going to be in the next movie, do a trademark watch on Lucasfilms. I knew the SO2 guy was going to be the new guy 6 months before the movie came out.
That's amazing.
Because they filed their intent to use applications.
Oh my gosh.
Now, having my word mark,
Mm-hmm.
is that what it's called?
Yeah.
Yep.
It's just
Okay.
letters,
Yep.
okay? And it's a combination of two words, not obvious, but evocative
Okay.
because of the word mark. Can I tell her what it is?
Yeah, word mark, single word, or a slogan is, say, probably 4 to 6 words, something like that.
Yeah.
But you know, there's so many ways to do trademarks, but the basic best value start is just a basic text, black and white text word mark.
Now, so you don't even want the design necessarily for word.
You can do that later, because those are each separate trademarks. So
Okay, you essentially just.
So it's just kind of like the money's adding up, so
Yeah.
see if the business goes first.
Okay.
The word mark alone gives you the most flexibility to grow and change a little bit. But if you're really tied, like if your word mark isn't going to get you over the hill from a descriptive or a generic perspective, and you do have a logo that you're happy with, you might want to consider that. But, right?
Yeah,
Those
because like
are-
we have, so our Easy Peasy logo is 2 circles. It has the letters in it, Easy Peasy. We have the word mark. We did not have the design mark in China, so people just took out the Easy Peasy, but it's 2 circles and they put a smile, so it looks like the exact same thing.
Yep.
But we didn't have our design mark.
It's all about the communication impression. Say like the Nike Swish, it's great if you go to foreign countries, you don't have a language problem.
Well,
But-
and no interpretation problem, right?
But on the other hand, the mark doesn't make a noise. You know, you have sight, sound, and meaning impressions. So like the bear one, it's silent. Nobody
Yeah.
can say anything.
Yeah.
Yeah. Oh, you know that's still Coca-Cola,
Yeah.
right?
Well, actually, I thought it was actually Klondike.
They're all.
I know,
I did not know that. That's hilarious.
So,
So how does, we understand first, how does that white bear in a square, I assume it's a bear,
polar bear.
polar bear, how
They've
does that?
used polar bears in their ads
Yeah,
for years and
sure.
years and years and
I
years.
don't drink Coke, I'm sorry.
I just like their advertising.
It's their Christmas campaign.
Yeah.
I like my thing.
Absolutely. Well, but most interestingly, right? Let me see if I can go back. This, that shape
Yes.
started out as a design patent. It's now a 3D registered trademark.
A 3D registered trademark.
That shape.
Right, yeah.
That shape.
I should have mentioned that, because
So
that's a
I-
way to stretch your design protections for into perpetuity. 'Cause
Well, I heard about
Design
that, because they said you couldn't make
patents
a bottle that,
Right.
like 50.
And the
Oh,
reason
yeah.
that, and that's because, right, that shape didn't have any function associated with it. So, right, let's talk a little bit about patents, right? Because patents cover methods of manufacture, hold on.
2 seconds. So today, if you register a trademark and it's cute, like Jaws twist ties, the next day, the domain name will be stolen.
Yeah.
Yeah,
Yeah.
so you do want to get your,
So
Want to
you
get the
better,
domain
you
first.
better register your trademark and the domain on the same moment in time, because you'll be buying your domain name back from a pirate the next day if you don't. And that happened to us like last month. And I'm a lawyer.
right?
Yeah, good, yeah.
Okay, so patents cover the functionality of things, unless you're in the plant patent or design patent world. So there are 3 types of patents, right? All right, so go with me here. Umbrella is intellectual property, 4 types of intellectual property: patents, copyrights, trademarks, and trade secrets. Under patents, okay, so there's 2 types of applications under trademarks: intent to use and use. But under patents, there's actually 3 kinds of patents: utility, plant, and design. Okay, utility covers how something functions. Design covers the ornamental features of the invention. And according to the design patent supervisory patent examiner that's in my office, ornamental does not mean that it needs to be pretty. It can be ugly. And I'm quoting. So, right, like Crocs, for example, ornamental, and that is a design patent that they own. A plant patent covers asexually reproducing types of plants, right? So the plants that don't have any fun. Oh my. Going back to Vegas. Anyway, no, Steve, you had a question first.
Yes.
And then Dana, I will get to you.
I have a design, trademark, a word mark.
A word mark.
A word mark. I have put it on my website. Does that constitute use?
Have you sold anything into another state?
No. And won't likely do that for 3 years?
Talk to Roger.
I mean, that's likely that it won't happen for 3 years.
Okay.
Roger.
That means I've got to refile, I'm sure.
Talk to Roger. There's ways that he's aware of,
Okay.
that can help you out. Okay, so under patents though.
You would be giving me a legal opinion, you're not allowed to.
Exactly, I'm not allowed to do that. I can only give you information and options. So actually, no matter what I said tonight, even if it sounded like advice, it's not. It's just information and options. For the record.
Covering your, yes.
I know. I have Lego sets to buy. Dana.
Okay, now you're saying, like the crop design.
Yep.
Crop. But I've seen it done in different variations. Are you saying that all of those are crops? Because I thought they were spin-offs.
Some of them might be spin-offs. And if they are spin-offs, that's Croc's problem to worry about. I won't make.
Didn't Croc have some issue?
They've had lots of issues.
Okay, yeah,
They've had lots of issues. That is their actual design patent.
Yeah.
But they've actually had lots of intellectual property issues as well.
And I think the guy was in trouble too. Something happened, maybe not. I'm starting rumors. Don't take that for me.
I don't remember.
Don't
So
take
don't take that as gospel.
That was
But anyway, so you get the design patent on the features that are ornamental, which is one of the reasons why, right? You can then, if it attains a big enough association with the goods and services, you can then transfer it into a trademark law, and therefore extend the life of that design patent protection. Because if it's the subject of a design patent, that means it's automatically not functional, right? And then can serve as that connection to the goods and services and have consumers make the connection between your goods and services and your mark.
Right.
Right, and
The
that
trademark can't be functional either.
Right.
It's the same thing.
Exactly.
Yeah.
So a utility patent though is functional, right? And there are two types of utility patent applications. One is called a provisional, the other is called a non-provisional. And let's be very clear about this. There are no provisional patent applications for plant patents or design patents or any other type of intellectual property, right? The only time you can get a provisional application is in connection with the utility patent. That's it. So it must cover how something functions, how it works, how it's connected, what it does, all put together in one application. A provisional application is something you want to think about. It's the cheapest way to get into the patent system. It does not give you any protection to enforce against anybody. It is basically a placeholder, okay? And one of the reasons why it's important is under the American Invents Act in 2011, prior to 2013 when it became effective, but it was put into the American Invents Act of 2011. Prior to that, America was always the first to invent country, right? So you had, as an inventor, as an independent inventor especially, you had some leeway in terms of what you were able to do and how you were able to do it before you had to file for your patent application. That is no longer the case, okay? The United States, like every other country in the world, is a first to file system. That means he or she who wins the race to the patent office is deemed the presumptive owner of that invention. It is crucial that you guys understand that, right? right? It really is a race to the patent office, especially if you are out there talking to people about your invention, right? Without the use of a non-disclosure agreement.
Or even with these.
Or even with the use of lots of drugs, right? So with us being a first to file country now, it is vitally important that you understand the use of a provisional patent application gets you an early filing date, and it gets you a serial number. That's it. And it gets you 364, not 365. It expires exactly 1 year from the date of filing of your provisional application. So, right, you get 364 days of being able to figure out, and I don't recommend 364, Rick. Start converting early, but you must, in order to be able to enforce that right, you must convert from a provisional to a non-provisional application. It must be examined under our statutes, 101, 102, and 103. We'll talk about those in a minute. And then it must issue as a patent before you can enforce. So, right, you've got to go provisional to non-provisional within that year, and then get an issued patent before you can enforce it.
Have there been any discussions of buying an extension on a provisional?
Yes.
Really?
Do you want more elaboration?
Would it contradict international uniformity? Are there any other countries that have a precedent in that area?
No.
No.
There are none. However, the United States still walked alone in terms of the grace period that you already have. So one of the things about being an inventor is that your own words can be used against you. So if you are out there selling or publicly disclosing your invention, and I'm not looking at you two for any reason, but, okay, don't do it. But if you do it inadvertently, you know, in Vegas, right, you have 1 year from the time that you disclose it to file an application in the United States. You will get that grace period in the United States. You do not have that grace period anywhere else. You've destroyed your foreign filing rights. Okay, so you're done. Because every other country in the world will use your own words against you. Right? So it's crucially important that you have liberal use of non-disclosure agreements if you think you want to file anywhere else in the world. Okay, so we talked about provisional applications. Let me tell you one more thing about provisionals. What?
Just to confirm on provisionals, if you file a provisional and then they want to add a feature to the invention and we're within the provisional life, you can file another provisional. Now we can't link them.
You can't link the provisionals.
Right, to each other, but then when we file the non-provisional later, we can pull in both priorities.
Oh, absolutely.
Together, okay.
Although you want to make sure that you file within the time frame of the earliest.
Yeah, all the
priority
provisionals have to
dates.
be within the year.
I actually filed a non-provisional application that had 6 provisional
Okay,
applications.
yes, I know people have done that.
That's
Yeah,
because my
multiple
engineers couldn't
provisionals,
make up
yeah.
their friggin' minds. Anyway,
So if it's in that window,
Not
you file the, you know, the change. You still have, let's say you filed a change and you had like 5 months of the 364. You just have the 5 months left then?
you only have the 5 months,
Okay,
yeah.
okay.
So
The
right-
way that made it sound
you
like
never-
you have.
No, you don't get to extend,
Okay.
right? There is no
No,
extension of
that's
the
what I
life
was
of a
wondering.
provisional
The
application.
window's based on the first file,
Mhm,
and then you have to have at least one common inventor
mhm.
too.
Yeah,
Because that's like, 'cause like for me, like the design for my, you know, provisional, like I'm redoing it right now.
mhm.
So,
From the first filing date. You never want to give up, especially in this world that we live in now. You don't want to give up that first filing date, right? You want to do everything you can to get your non-provisional filed by that first filing date. Now, the one thing that everybody asks me is, provisional applications in the Patent and Trademark Office. I mean, when I say that you get a filing date and a serial number, that is all you get. Nobody looks at it until you convert to a non-provisional.
Right, it stays secret.
It stays completely secret until you convert to a non-provisional. Now, when you're thinking about your provisional patent application, you need to think about it as the platform, right? And that's the platform from which your non-provisional is going to spring. So everything that's in your non-provisional has to be in your provisional, And you may actually want, right, to put more in your provisional, then you're actually going to end up filing in your non-provisional. Because that provisional has to have everything. It has to form the basis of your non-provisional application. So think of it as the platform or the trampoline, right, off of which you're going to spring your non-provisional application, right? And then once your non-provisional application is filed, it will get assigned to a technology center based on the claims. It will then get assigned down to an art unit and then to an individual examiner who will pick it up somewhere around, all things willing, and if the government doesn't shut down, 18 months, 16 to 18 months after your non-provisional application is filed. So, and then it just goes through the normal process. You should know that 90% of applications are rejected the first time. Please do not take that initial rejection as an excuse to find the tallest building that will have a window that open. That is not what we want you to think, and it is not a rejection of you personally. It is just how we are. Not kidding about this.
Is that because the government?
I can't
I run into that same problem with the VA.
But, right, like, so, but what you should view it as is what I call an invitation to talk. So one of the best ways to get your patent application through the U.S. Patent and Trademark Office is to actually talk to your examiner. I promise you, I have about 100 of them at our Rocky Mountain office. They're all people, no matter what you may think. Yes, they work for the government, but we're all people. And so pick up the... We do, inherently, I believe that. No, and actually, like, some of our examiners are really, really fascinating. I've got one guy who throws himself out of planes, and he's actually set 2 world records for skydiving. Of course, I think he's crazy. He thinks I'm crazy for doing this with you. So, right, it's how the world works.
Yes.
You know, we've got our own beer making club at the office.
Yeah.
Yeah, right, so we're people too. So just pick up the phone, talk to us, interview the examiner. If you happen to get lucky enough, so one of the things that we do not do at the Patent and Trademark Office is we do not co-locate inventors with examiners. So there's no locality factor that we put on any patent application. So if you are lucky enough to get an examiner who is here in the Rocky Mountain office, and you can tell by the 303 number, call them up and come in for an interview. If you happen to be representing yourself, so while you can find amazing patent attorneys in this town, and one of the things that I love about the Denver IP community is the people that is in it, you are hard pressed to find an idiot or a jerk. We have an amazing IP community in this state and in this town. You do not have to have an attorney. There are ways for you to represent yourself. It's not something I recommend. It's not something that the office recommends, but we have the mechanisms available for you. And one of the things that we found out is that when we would put someone who was representing themselves, which, by the way, we're lawyers still, we like Latin, so we call you pro se. Okay, right. That means for yourself in Latin. Pro bono means for the good. We'll talk about pro bono in a minute. But when you represent yourself in front of the office and we just put you with a regular examiner, we found out that everybody had a really bad experience. You guys got frustrated, our examiners got frustrated, it wasn't a good match. So what we did was we created what we call the pro se art unit. So about 3% of the 630 or 40,000 applications that we receive every year are people who are representing themselves, so 3% of 640. About half of that 3% go through the pro se art unit, and those examiners are trained, they're given extra training, they're given perhaps better people skills than you might expect from your normal introverted engineer or scientist, who then went to law school sometimes, right, showing a particular aspect for punishment, or trait for punishment. But right, like, so we give them extra training, and then they know the bounds of where they can help you. They'll help you draft a claim, and help you get through the process. And they're given all that extra training. They're also given extra time. So it works out really well for those examiners. And Denver is the only regional patent office that has a pro se examiner in it.
So cool.
So it's very, very cool.
How
Now,
many
we're hoping that all of the application, that all of that 3% are eventually gonna go into that art unit. They're not right now. So if you're not in the pro se art unit and you happen to be representing yourself, my recommendation to you is that you tell your examiner that you're representing yourself, because that examiner can use that to go get extra time from their SPE, and that makes them much more willing to help you, right? Because that's how they're rewarded, is how they spend their time. So, yes, sir.
Little points here. They will check on a provisional your figure count. If you say figure 1, 2, 3, and you only have figures 1 and 2.
Oh, okay.
They'll take it back, number 1. Number 2, so somebody reads it.
Only the pre-processing
It's
people.
not a robot, but nonetheless, next year. you
Might be
never know.
moving there.
The whole staff's gonna be.
Rick, our IT system doesn't support it right now, don't worry.
That foundation speech is extremely important because if a 13-year-old cannot build it from your provisional description and drawings, you probably have not secured a filing date in the real world. Because the key word is enablement. And I always use a 13-year-old, because they're pretty cool, but they don't have.
And they think they know it all.
Yeah. Well, they have the ego, probably carrying through a lot more
Yeah.
than most of us. So, but of course, if it's biotech or micro nanotechnology, or things that you need 8 years to get in the door and understand the molecular,
Right.
whatever, then of course the enablement is at a very high expert level.
Right.
But if that enablement is not there in the provisional, you have not secured your date. You've probably blown the foreign dates, and you basically are sitting there without a patent filing. The real problem, there's Patent It Yourself, by the way. That book is a great book. He made
really?
more money on the book,
Okay.
and he's a patent lawyer. I think he's retired. I met him at a yacht base in Fort Lauderdale. Cool guy. And but there's a sequel. It's called Fly Yourself by John Denver. So if you think you're going to patent it yourself,
That's so wrong.
you want to read the sequel.
I missed it.
John Denver died in his experimental.
Oh. That went right over my head. I'm glad I'm like.
And Rick, I am still grieving that loss.
Oh my gosh.
So don't.
Rocky Mountain High. So at any rate,
No, more the Muppets Christmas.
you can't possibly get in to flying a plane.
Well, and that
or
leads
writing a
me
patent.
to my next point, right?
It's not even in your possible feasibility, and you just don't do it unless you hire a patent agent or patent lawyer who's at least got 5 years under his belt, or was working for somebody that has 5 years, or you're really gonna blow it if this thing turns into an easy peasy and it does take off.
Well, and that's the point. You are creating what may become the most important asset of your future company. So when you're creating that most important asset, what do you think you want? So while I have to tell you that you can represent yourself, you need to be thinking about, you're creating the most important asset. And one of the things is, remember when I talked about them being assets that are monetizable. So does everyone remember Jawbone? Great speakers, little miniaturized, yep. So that they went bankrupt, right? They're going out of business, but their patent portfolio alone is going to return somewhere in between $40 and $80 million to their investors.
Jeez.
Yeah. So, right, when you're creating that asset that might be the only thing that's left, if your company goes belly up, think about who you want doing that. And maybe you have the confidence of the 13-year-old, and you're willing to let us help you. But at the same time, you really do want to be thinking about who you want to hire and how you want to do it. And I know Lindsay's going to say this at some point, because it's all about the people, and it's all about the team that you assemble around.
I was going to say that, but I was also going to say that's so good. It's absolutely about the people, but it's also, that before Easy Peasy, I had this false perception in life that all lawyers are created equal and all doctors are created equal, and that is so false. It's every lawyer is a person. and people are gonna work harder, and they're gonna be better and smarter than the other people. And I have trusted, I mean, even just getting into, that's why it's great, and then get more opinions. Like, even after it's registered, hire someone like a Rick that's gonna say, okay, here's what I would do if I was going against you, and it's been very insightful, so. But just don't, I mean, always follow your gut and don't trust people.
And I think you need to have the 50 ways, so that you can then, like, parody the Simon Garfunkel song, right? 50 ways to leave.
50 ways. Am I-
50
I'm
ways to
missing
kill
it?
the
I'm missing
patent. But 50 ways, I'm not singing tonight.
Well, killing the patent issue.
Oh, 24
See?
ways.
See, you had 24 ways.
24, there's 24 ways I was taught years ago to kill a patent. And that number, just had counting my, in other words, it's a very fragile instrument. Half of them die in a courtroom battle. The statistic. Okay, so it's like a glass jar. It's a very fragile asset. It's like buying State Farm insurance for your car that will pay half the time. But it's the only insurance policy available. So, and it's really a little better in Germany from what I hear, where they have regional patent courts with judges that are patent lawyers. And we don't have anything near that, not in our life, not in our grandkids' lifetime. I don't think it's that going to happen. But it's the only game in town to protect, the utility patent. And that's just the way it is. So it's very fragile, it's risky. Craftsman has to bill those words. And we get, I will have a negligent act in every patent I've ever issued. There's something negligent in every one. Somewhere of the 24 ways to kill it, I'll bet you'll find one of them in every patent I've ever issued, no matter what. I've trained 20 patent lawyers over 30 years. So
he's saying someone can always find a way to poke a hole, and people will try, and then it's fine to get people to defend it.
And half the time they'll win. There's just something wrong with the whole. You can't sit on my words. Think about that. But you can sit on that simple chair. But no matter what you pay me, I will never enable you to sit on that bunch of words I wrote to cover that chair. We always fall so far short with our words.
Because we use the English language, and the English language is inherently limited. But one of the other things, we were talking about searching, and we do recommend that you use either one of our patent and trademark resource centers, and you can find the map on our website, but thanks to me, we now have a PTRC in Grand Junction and Durango, so that people in the Four Corners area don't have to drive 8 hours over 3 mountain passes to get to Denver, because prior to, last year, people in the state of Colorado only could come to Denver. And there was only one in Denver and one in Wyoming. There was nothing in Nevada and nothing in Arizona.
Oh my gosh.
And the one in New Mexico is in Las Cruces. So, so use the Patent and Trademark Resource Centers. And one of the reasons why I tell people to use them or to come into the Denver regional office when you're doing your prior art searching. So if I put a screw in front of you, what would you guys call it? Like just a regular threaded screw?
Fastener.
Embodiment. You're getting close. I call it a removable fastener.
Means for attachment.
Or a means for attachment, right? And that's one of the reasons why you want to have our help and you want to be searching the databases that our patent examiners search. Because Google Natural Language is fantastic, but it will only get you so far, okay? Especially if you're using your terminology and not mine.
Yeah.
Right? If you use East with us and you come in, we will help you do a classification search that will help you uncover more than you would find using Google Natural Language, and it'll get you closer to where you are. Hopefully you don't find anything that's dead on, right? And if you don't find anything that's dead on, maybe that's the space, that's that white space where you can go. But if you do find something that's dead on, then you know you need to pivot, right? Either you're going to license that technology from the person who already owns it, or you're going to come up with something new. So prior art searching before you start really investing money is super, super important. All right, we talked about that. I just want to point out, because I feel the need to do this on behalf of my colleague Hope in the Dallas office, it is Girl Scout cookie time.
What is that? What is that?
The Girl Scout symbol.
Oh, is that Girl Scout?
Oh my God.
When was the last time you had a Girl Scout? So that's
My girl is a Civil Air Patrolman.
She was a Girl Scout.
She was in the Air Force.
Anyway, okay. and that's Boy Scouts, by the way. So,
I didn't know that.
we talked about traditional marks. Oh, wait.
Totally, yeah.
These are some of the stylized marks.
Boy Scouts.
Right? I know. And their popcorn is, trust me, I have to sell it because it's a book. Anyway, right, so these are some of the stylized marks that people have come up with. You can see like the A in Samsung doesn't have the little bar across it, right? So you can sometimes try and be cute about some of those things, but, there you
I've
go.
got a question for you.
Yep,
We were speaking about the apple before. Now, that one has an illustration. But as far as the Beatles go, now, when they had to talk to those folks, did they have to talk to them about that one as well?
I don't know. I think it was just the name Apple.
Okay, not in the illustration.
Mm-hmm.
Molly, I have a question.
Yes, Jay?
A ways back, you said that this provisional patent
Right?
gave you a number and the registration date. And the thing was secret.
Filing date.
Filing date.
Filing date and a serial number.
And it's secret.
Mm-hmm.
So how, if you're going to do something and do a provisional, how do you find out if somebody else has set up a provisional that's the same as yours?
You don't. That's an inherent risk in the system.
Yeah, so there's a, well, I guess you could say an 18-month time window, basically, of blackout.
Mm-hmm.
You don't know the recently filed stuff. It might be dead on, but everybody faces that.
Yeah, okay.
So
Yeah, I was just
it's a
curious.
way of, you give the inventors some advantage on secrecy, but not
Too much.
forever. Yeah, not too much.
Yeah.
Yeah, okay.
It's all about balancing. We talked a little bit about non-traditional marks, colors. That in particular is my absolute favorite color to see in a box.
Yeah.
For the men in the room,
Yes.
thank you.
The house is broken.
Okay. Scents, for whatever reason, Play-Doh has trademarked their scent. Anyway.
Yeah.
Sounds, we talked a little bit. Trade dress, those are my favorite boots ever, Dr. Martens. The Hershey's Kiss, that's an Apple store, that's trade dress. And then the Coca-Cola bottle. We talked a little bit about copyright. Those are, I'm actually gonna get to see the Mona Lisa's name. Okay, this is my favorite, myth busting. So how different is different enough? For copyright, remember we talked about the standard with substantial similarity? What's substantially similar? Give me a number.
$1.398.
No, so if you read on the internet, they'll tell you that if you change something by 10% or more, that you will avoid copyright infringement. I would like to point out to you Pharrell and Robin Thicke. They took 6 beats of a Marvin Gaye song and evoked
I've heard about
feeling in Blurred Lines, and they paid the Marvin Gaye estate $7.4 million, as well as ongoing royalties from that song.
No way.
6 beats and evoked the feeling is not 10%. So do not believe what you read on the internet. Okay. I'm pretty sure everybody here was in that camp already, but that's the one that always makes me nuts. Okay, it's okay if it's not for commercial use. Well, actually, we'll see. But most people will tell you that if it's not for commercial use, to copy someone's copyright is okay. It's actually not true. There are certain places and certain things that you can do for fair use. Those are really complicated analysis. And in my grandfather's words, if you're arguing, you're losing.
Well, I gotta throw 2 cents. So if you download a photograph from the internet, you don't pay for it, you will get your ass sued, I guarantee you.
Oh, yeah.
Now, a federal judge, our senior judge, ringed me out today in writing for putting forth the argument that my poor balloon operator downloaded a picture of a balloon festival because it was in 6 free download sites on the internet, including Pinterest, which has everything under the sun there, and 4 other ones, travel logs, etc. She said, how dare you, Mr. Martin, imply that that I should not fine him much money at all just because he downloaded something that's free on the internet. Shame on you, that's the second time you did that, you asshole, Mr. Martin. Sorry. So, I'm being spanked for doing this policeman job of trying to protect you guys, the public, because the law now, the statute is so flawed that for, actually Disney World wrote the copyright statute, it's called the Mickey Mouse statute. Nonetheless, for absolutely no damages that you created, you could be sued $150,000 for clicking the button and downloading a picture of a woman.
This is crazy.
And it's the 100% power of a federal judge who has the death sentence power. Okay? She can kill you. Okay? And she can also fine you.
We appear before her in criminal
You
court.
see?
She has yet to get a lawyer for sanctions.
So every judge, of which we have over 1,000, has the power to fine you $200 or $150,000 plus the legal fees of the other side for clicking a download of one photograph of a dog.
And
Using it.
That's it.
It's using it.
And using it.
You've got to use
If you
it.
didn't use it, they wouldn't find you. There are machines out there called spiders, reverse photograph spiders. So if you use it on your website, an electronic spider scanning the whole internet is going to find that image and sue you. So when it comes to this fair use stuff, be careful. The laws are screwed up. We're way behind. There shouldn't be a way to sue you unless that photograph is worth something. If the photograph's for sale for $9.99, in my case, $600, then yeah, you can sue me for $600, end the case, send the guy $600. No, my guy has to fly 1,000 miles. My guy has to hire me. We have to go to court. We have to spend 5 months filing papers to get to court because he went click and took a picture of a balloon, probably photographed from his balloon. He's a balloon operator.
It's so crazy. And there's also scammers, I'll just give you this, I don't know, but like people will get people to download and then it's scam you and call and even say just, hey, we're gonna take you to court, pay us this, and they're just like getting money, it's like this whole scam.
Well, that's pornography. There's a problem.
But it's
There's
a
$1
scam
billion
system, I heard.
pornography industry today.
Yes,
A
this is crazy.
700-man law firm is promoting the lawsuits, Fox Rothschild. They are now plaintiff filing a lawsuit every day, maybe 10 a day, because there are professional porno makers doing this for 5 years now, and they seed the whole internet with porno flicks that look free. There's no warning, but if you hit the button, the statute says that's a download, and by the way, it's for your own private use. You didn't use it commercially. You downloaded a porno flick, which you could probably buy for $4.99.
Crazy.
You're now going to get a phone call from first one. I've had 2 clients who turned down $15,000. We have just sued you in Denver. You are Mr. John Doe 3.
This is crazy.
We know your ISP. We know your name. We're going to put your name public next week, Mr. John Doe 3. And you're going to be hiring a defense copyright lawyer at $400, $500, $600, $800 an hour. So we can pay us $15,000 now and let us get this case resolved. So, and they are professional sealers. It's called Malibu and Strike 3. Every day you can see 5 or 10 lawsuits, and now a 500-man law firm is doing the suing. It's so unethical. It's our culture today. Don't hit the internet download button unless you expect to pay or get sued. There's only 2 things going to happen.
Crazy, good story. I was done.
So if I downloaded a movie from Netflix and I wasn't a subscriber,
Well, you can't download movies.
oh, yes, you can.
Well, I don't know.
When you're using a program called Torrent.
What?
That's called BitTorrent. That's where all the porno comes from.
Right.
It's called BitTorrent, and that's where you can get all these free, or maybe, I mean, they put them out there on purpose so that you're fooled into a download you think is free, and the next thing you get a $15,000 phone call because they traced your download to your computer.
Crazy.
Can you touch on so that people know the distinction between statutory damages as it relates to copyright?
So,
There's a window of time.
yeah, there's a window of time for you to file your copyright registration. I think it's 4 months from the 4 months from the date of publication or prior to publication. And then you can qualify for statutory damages, which are the $150,000, or it's $200 per copy.
It's
Right.
200 to 150,000 per copy.
Per copy. And those are statutory damages. And one of the reasons for statutory damages in the copyright world, where there aren't any in the patent world or in the trademark world, is that, proving lost profits from any kind of an intellectual property suit in the copyright world is difficult to do. So you get the statutory damages to give the copyright a little bit more teeth. Or at least that's the way Congress thinks about it.
How likely is it that a judge would order the statutory damages?
They will order it. The
Oh, no,
question
they
is,
will.
We're in the spectrum of 200 to 150,000, and, 90% of all these people sued, they settle for $2,000, $5,000, $10,000, because they don't want to know. The guy I'm fighting has sued 60 people in the last 18 months, and every one of them except me has settled. And I'm building a record online of a summary judgment, all the suit, the history. So the next guy this clown sues is going to read my record, even though I'm getting beat up. You get it? And that lawyer is going to read about this guy's a real, he's a real setup artist. They're called copyright trolls, honey traps. What are they called? Honey traps.
I think.
Yeah, there's lots of names, but it's copyright troll. It's $1 billion industry with the fee, and it's full of lawyers. You can't do this without a lawyer who has a ticket.
Because they visited the places where the lawsuits are coming out, they're empty buildings.
Yeah.
It's like, there's a town in, I think, Texas?
Marshall, Texas, yeah, the Tex piece.
Oh, no, that was on the patent side.
Well, that's patent.
This is trolls. Yeah, this is different.
Yeah.
No, non-practicing entities.
Yeah, like that town, where it's just like empty buildings.
We call them non-practicing entities.
Yeah.
Yeah.
We can talk about that in a second. Okay, so we talked, hold on, trade secrets. The Google algorithm is a trade secret too. We talked about the Pro Se Art Unit, and that's our attempt at animation. Judge for yourself. The other thing that we did, recognizing that the America Invents Act, in putting the first to file on independent inventors especially, put an extra burden on you, on small businesses and independent inventors, because trust me, I worked for the large corporation. I guarantee you I filed before I published every single time, because my company was always interested in foreign filing. So that was how we rolled. The people who needed the protection most of that grace period and that first to invent system was you guys, was the small businesses. And so one of the things that we did was we created a pro bono program, so that is for the good. Every lawyer has pro bono requirements, judging whatever they might be from the state that they work in. And quite frankly, I would have killed for patent pro bono when I was doing my pro bono requirements, because I represented domestic violence victims. We established the patent pro bono program, and the one that we have here that's run out of Mikasa Resource Center, you'll pay a $50 application fee, but they match you with an attorney who will provide you patent application drafting services for free. Right, so you create the relationship you want to have with them. I think it's a really amazing program. It's been, universally loved on both sides for the people who are doing it. For those of us who are attorneys, it's a great way to get a client in the door and help somebody on the way up. Those tend to be the most loyal clients too. So anyway, that's Jennifer. We do have a waiting list. That's the problem. So if you are in a hurry, you may be forced to, find your own patent attorney and pay for it.
How long is that waiting period?
I think it's, the last time I asked Jennifer, it was almost a year.
Okay.
Right? Okay. So, a couple of additional resources. This IP awareness assessment, I like to liken it to, which Game of Thrones character you are. And I use Game of Thrones again because it's starting soon. Winter is coming. And, okay, so the IP awareness assessment though, One of the things that I love to do with people is to kind of do an intellectual property audit with them. We can actually start right here in this room, and I guarantee you, I will find a piece of intellectual property that I absolutely know about that you did not, right? And so this IP awareness assessment just walks you through your business and kind of gets you woke to the intellectual property that might be lurking that you're not thinking about protecting yet. And one of the things, again, anytime you're thinking about intellectual property, you want to be thinking about everything under that umbrella. Patents, copyrights, trademarks, and trade secrets. Whatever combination works for you and your budget and how you can proceed right now, right? So that's one of the things. Our patent and trademark resource centers are right there. We do have a law school clinic program here in the state of Colorado. However, you have to be part of the entrepreneurial law clinic up at UC, or CU, sorry. UC. Anyway, you have to be part of the entrepreneurial law clinic in order to take advantage of that. I'm actually still talking to DU about perhaps starting up a law school clinic. We'll be open to more members of the public, so you don't have to be part of that entrepreneurial law clinic in order to take advantage of the patent law clinic. You can always come see us. There we are. So we're on Facebook, we're on YouTube. We tweet. I don't tweet, as you might be able to tell. I don't say anything in 420 characters. And then we are also on Instagram recently. I know. So, and then you can always come in and see us at www.uspto.gov/Denver. Any questions you might have, give us a call. Yeah.
How busy are you?
Why are you here right now?
Don't ask my child. He'll have an answer for you that mommy's too busy. No, you know what? It's kind of funny because we put it out there, and it's shocking to me that people don't take us up on it more often. Come see us. I totally mean it. I mean, I recognize completely, and being a federal government official, and I'm here to help, that might terrify some of you. But it's completely true. And Roger, you know this, it's completely true. No, it's really, at least for me, right? So we do a lot of education with the large corporations, but most of them hired in-house counsel like I used to be. And they have experts there on staff. So they aren't the people who need, kind of that information and that starting help and that starting hand. And the relationship between intellectual property startups and the economy is absolutely solid. It is direct, it's linear. And the more we can help you create businesses to create jobs and improve the Colorado economy, I'm all down for that.
Yeah. When you say come in, do you mean like where it's like, hey, unannounced, come in, or like make it fun?
If you want me, hey Molly, might be better to make an appointment. Of course, my executive assistant, she said just come in. I know she's here. No, my executive assistant actually has this cartoon on her door because she's got a wicked sense of humor, which is probably why she survived working with me for so long. And I adore her. Thank you, Dara. But it says, it's got the receptionist in front, and it's got my name on the door, and it says she's got a 242 and a 243, but I think I can fit you in.
That's amazing.
So yeah, so if you want me, then definitely, right? But we have a whole staff. So we have a staff that can help you through the searching part of it. We have an expert staffer on site that does the searching, and she even helps our examiners do some of their searching. And then we have supervisory patent examiners that can talk to you about, different aspects of the patent system. If you want trademarks, it's probably myself or my assistant regional director, Mark Radke. So.
Okay.
So that's when you would want to call.
Okay.
Has the government shutdown affected you at all?
Not yet. So the U.S. Patent and Trademark Office, which is probably one of the reasons why I felt comfortable joining, runs like a business. We are the only fully user fee funded agency in the federal
They're
government.
self-funded, so they're not
Oh.
dependent on allocations.
Absolutely.
But a lot of agencies
That's
are.
why
We
a
take-
patent application is as expensive as it is, because you've got to use that money to run the whole darn system.
Absolutely. Right. And we tailor our fees we look pretty closely at our fees so that when you tally up what you paid from the start of the patent application all the way through to that third maintenance fee, you really have paid for the amount of time that it takes an examiner to process that application. Now, what we do from a public policy perspective, because we are a government agency, is we end load those fees. So that's why your third maintenance fee at that 11 and a half years is so expensive, because that's where we're recouping, because we want to make sure that the intellectual property system is accessible to everyone. We take that, our foundation is in the Constitution, and honestly, reading the letters between Madison and Jefferson about including Article 1, Section 8, Clause 8 in the Constitution at all is fascinating.
Oh, that is cool.
It's the most amazing conversation. Madison was absolutely adamant that that needed to be in because he felt that America would not succeed without strong intellectual property protections. Jefferson, though, was very familiar with the French and the English patent system, which was much more a system of patronage than actual patent at the time.
Royal grants.
Yes, and so he was adamantly opposed to having the patent clause in the Constitution. And then this is my favorite saying, because it's like, be careful what you agree to in the federal government, because you might end up doing it. So Thomas Jefferson was the first patent examiner. There's sort of justice in that, right?
Can you touch a bit on advancements in an idea between the time you submit your provisional to your non-provisional?
Okay, so any design process is iterative. And so what you want to be doing with your patent application, provisional and non-provisional, right, is you want to get your invention to a point in time where you're comfortable with it and you think that this is probably where you're going to go. If you have not yet filed your non-provisional, you can file, like Roger was talking about, you have a provisional, let's say that you filed 2 weeks ago, and today I said something that was so brilliant that you had this like totally great idea off of that.
Okay.
Right? Yeah, okay. And so you're like, oh no, I'm going to incorporate that now. And then you file another provisional. So when you file your non-provisional, though, you're going to file it from the one you filed it 2 weeks ago, but then you claim priority back to the other provisionals, right, in your chain. Because you can't connect the two provisionals from a priority perspective, but you can put a number of provisionals in for your non-provisional and claim priority back to all of them, so long as you're still within that 1 year from your earliest filing date.
See, but that saves you money because the provisional file fee is very low. Because if you said,
I think
well, I'll
under
roll it into a
micro-entity, it's
non-provisional,
what?
then you're paying the full file fee.
The micro-entity fee for patent applications is what, like $70?
70, and then 105 for small.
Yeah. So that's the other thing about our fees, right?
430 and 760.
Yeah.
Which goes up.
So one of the things that we did with our fees as well, because again, we are a government agency, is we actually prorate our fees. So any small business, 500 employees or less, we use the Small Business Administration's definition of that. They get small entity fees, which are a 50% reduction off of the large entity fees. And then we actually instituted with the AIA a micro entity fee, which is a 75% reduction. It's got some other requirements, including that you can only have 4 applications in your name. Now, one of the interesting things about that is if you worked for a corporation before and you filed 50 patent applications as the inventor, but they were all assigned to your other corporation, you, as an independent inventor, still get your micro entity, but only for 4 applications, right? So we're giving you a break, but not that much of a break. Hey, you gotta support the creative thinking that goes on in government, and that I honestly love that micro entity fee.
Because you're paying below their cost in the initial file fee.
Right.
So like if you're a micro entity at 430, I think their cost is about 2,500. Somewhere in there, so that they're gonna make that up in maintenance fees and issue fees later on. So
what you really want is every single patent to be successful so that you can get the back end.
Absolutely.
Right, but the back end isn't 100%. It might be 50% or something, so.
If it's a small entity and it goes all the way through,
Yeah.
a small entity, no. But what we really want What we really want is for you to start out as a small or micro entity and then get bought by a large entity. So those last fees are paid on the large entity side. So we want you to be successful. It's totally in our best interest to do that. Okay, but Steve, going back to your government shutdown. So while we do not take any taxpayer dollars, and we have never taken taxpayer dollars.
Never?
Not since we became the U.S. Patent and Trademark Office in, I think, 1970.
So before that, whenever that was, long prehistory, it was all government financed.
Yeah, in the early days,
Okay.
220 some odd years ago.
Right.
In modern patents, though, the fees have always kind of covered. And prior to the America Invents Act, we actually acted as a cash cow for the Congressional General Fund.
Congress took.
They took anything that we didn't spend and over and above. With the America Invents Act, though, two things happened. One is that we had the ability to set our own fees, and that fee-setting authority was just extended, which is really good because that allows us to be more responsive to the things that we think are working or not working on your behalf. And then the other thing that it did was it allowed us to create a reserve fund. So we are authorized to spend whatever we collect, up to and including what we spend, and then up to funding this reserve fund. So what happened when the government shut down is that our ability to spend what we collected expired. So basically our bank account was frozen, right? On December 21st, it was frozen. We have a pot of money that we are continuing to operate under normal operations for until whenever
And
that
that
money
kind of money
expires.
is your contingency fund.
It was our reserve fund as well as some of our collections from this first quarter fiscal year 2019. Which is what we're in right now.
Fees still going in?
Hmm?
The maintenance fees are still going in, aren't they?
Yes.
Maintenance fees.
Oh, absolutely.
But
We
they
have
can't-
the ability to collect from you. We do
Right.
not have the authorization to spend.
They can't pay your salary,
Two different things.
right? They cannot pay the examiner's salary, or is that?
If we end up running out of
Oh.
prior year collections, we will not be able to pay anybody,
That's a unique situation. Every other government employee is just not getting paid.
right?
But, okay, you got 10,000 a year PTO. give or take.
Whatever it is,
Yeah.
whatever the number is, right?
So, okay.
Yeah.
Is there a projection of how many months, weeks, or days, or seconds? I'm sure there is. Is it public? Could you tell us how long you think your paycheck will continue?
Weeks,
Weeks.
Weeks?
Whoa.
weeks.
Wow, that would be it.
And how many people work for you directly?
For me directly, like in my direct management chain, just a couple. But we have, in Colorado, we have over 200 US patent and trademark employees. Serious business. Call your congressman. Keep the
So
government running again.
Why would they do that? Why can't you just use your own money you collect?
Because we have to have the authorization from Congress in order to spend the collection fees for every year that we're in.
Really?
Yep. So we don't have the authority to spend. We have the authority to collect.
Oh my gosh, good lucky you.
But right, like, the good news about that is, the minute that the government opens back up, if we shut down, and that's a very big if, right? If we shut down, then it would be, we would have that pot of money that would be ready to go for people to be, moving things along, and we'd be putting a lot of pressure on the examiners to, work some overtime and get us down. Because one of the things that we're very concerned about, we recognize that getting a patent into the hands of startups and entrepreneurs is really important, and it's important that we do it quickly and efficiently and reliably. So, right, like, we want to make sure that we keep our pendency goals down. And one of the biggest concerns that we have right now is that if we have to shut down, that pendency goal is going to go up. So instead of 14 to 16 months, that one's mine. Instead of 14 to 16 months to your first office action, we could be looking at the days of 2024 again. So call your congressman, tell him to open
When
up.
I started, it was 6 months. 6, 9 months got a patent. And then, and back, you're back to that if you pay them an extra $1,000. You know?
Under track one, yeah.
Yeah, I mean, that thing works like a whiz bang, and you're fool not to go $1,000 extra bucks as a micro entity.
Yeah.
Because
Wait a minute.
A track one, you can file, so there are a couple of ways that you can move your application to the front of the line. One of them is called track one.
Yes.
The other one is called a petition to make special. There's a couple reasons for a petition to make special, but the one most people take advantage of is perhaps the one that says that you are over the age of 65. Please don't make me explain why we want you to have a patent faster if you were over the age of 65.
Oh my God.
Yeah. Just, we're gonna stop
My
that.
heirs are gonna thank you.
Anyway, we're not gonna go there. So actually, one of the first presentations I ever did, and I was explaining that, and there was a gentleman who perhaps looked very wise in the front row, and he kept pressing me. And finally, he made me say it. I was just like, oh my God, I can't. He was so cute.
Oh my
God. All right, anyway, or you can pay the track one fee, which is basically $1,000 for a micro entity, and it gets your application to the front of the line. If you do pay track one though, do recognize that you can like move yourself out of it if you're not as prompt as we need you to be. So you've got to be as responsive, and then we will make sure that we're as responsive. It's a two-way street on that, and you get moving, so.
But if I do a track one, I'm
You
gonna
can-
be talking to your office,
No.
not somebody across.
No, you will be talking to your regular examiner in the course of the business. And the examiner can actually be anywhere in the 48 contiguous United States or Puerto Rico. And so you really don't know where your examiner is. And about, I want to say 95% of the patent staff are telework eligible. And I want to say over 70% of them work from home full time.
Oh, really?
Is that fast track only available for micro entities?
No, it's available for all entities. Large corporations don't tend to take advantage of it unless they've got a special product release that's coming up that they think is going to be disruptive in the industry. Most of them don't think it's worth it. For small entities though, or micro entities, it does tend to be worth it because you're usually at the point of raising money. And if I had $1 for every time I watched Shark Tank and I said, do you have a patent? Do you have a patent? I'd be so rich. I might work for the government for free, which I don't do, but anyway, right, like, so yeah, it really does help raise money, and get you, you know, at least in the door in some places. I've heard rumors that there's like one company in the valley that won't even talk to you unless you have 3 issued patents. Because without 3 issued patents, they think you're not serious about your intellectual property strategy. So, right? It's just kind of how it rolls. All right. Any other questions? I've kept you on task, so.
Are the sheets up there?
Absolutely. Roger printed out some of them, and I think you did,
I sent it out in the
but
email
Brad, I
too.
think
Oh,
you
I'll just grab, I
get
like a little hard copy.
you get the Inventor trading card. Thank
You have it in
y'all.
your email.
Come see us.
Who wants one?
We're just the people that
You gotta
maybe
do
don't
it.
get emails.
Well, it's the minimum, okay. Well, it's for the people that don't have, don't get the emails.
It's just a lot of,
Oh, it's what she said on the.
yes. it's-
Oh, it's-
See you later, Dave.
Right, go, see your roll, take your roll.
Well, I didn't know about the, what is the deal about if you're over 61?
Oh, we just make special, well, it's,
How often